Welcome, everyone, to the April 19, 2024 edition of the Zoom Employer Handbook Office Hour. My name is Eric Meyer. I am a partner in the Employment Practice Group at Pierson Ferdinand. I am also the publisher of the Employer Handbook blog, which you can check out at theemployerhandbook.com. Thank you all for coming today. We appreciate having you here. Got a lot to talk about over the next hour, focused on the Pregnant Workers Fairness Act final rule that the EEOC published this week. I'm going to ask people to stop their video. I thought I had that setting done, but I guess not. So everyone, please keep your video off. We're on the honor system here. And while we're doing that, and I'll try and tweak the settings, I'm going to turn it over to my partner, colleague Amy Epstein Gluck, to introduce herself. How you doing today, Amy?
I'm great, Eric. Thank you for asking. And hi, everyone. It's so nice to be able to talk about this subject today. I read it on a plane, all 400 pages, so you did not have to on Monday. As Eric said, Amy Epstein Gluck. I am a partner and the chair of the Employment, Labor, and Benefits Group at Pierson Ferdinand, LLP. I'm also the firm's employment counsel. And we are just so thrilled to be here, talk to you today.
And thanks for being here, Amy, and thanks to everyone. I am going to multitask today, monitoring the waiting room, monitoring the chat. If you're out there having a great day, say hello. Let us know you're here. That's how you can ask questions of us. I think everyone should be muted. We've had a couple people do a quick pop in on video. I thought I'd turn the video off for everyone else, but if everyone would please keep their video off, that would be great. Some people have asked, and you're going to see this if you're watching it on YouTube. Yes, this is being recorded. Yes, I'm going to post it to YouTube. And yes, I will kick out the link in a post on Monday. Also want to remind people that we have the closed captioning turned on. So you should be able to go down to where the three dots are at the bottom of the screen and turn on the closed captioning if you need it. And let's do a disclaimer. Real quickly, Amy and I are lawyers, but we're not your lawyers. And even if we are your lawyers in private practice for the next hour, we're not your lawyers, okay? So nothing we say is intended to be legal advice. Nothing we say is intended to create an attorney-client privilege with anyone, including the questions that we answer. So if you have questions, you can put them in the message chat, although I can't guarantee we'll get to them today because I did request in advance that people submit questions, and we got a bunch of them. So we're going to try and answer those. We'll give those priority. But if people have burning questions that are hypothetical, that aren't too specific, put them up in the chat and we'll see what we can do. All right. All right, let's get started.
So, I love all the hellos coming out.
What's that now?
I love all the hellos coming out on the chat. We have people from all across the country.
That's awesome. I was focused on the one person who said go Sixers, and indeed, go Sixers. Go Sixers. I'm gonna see a lot of Knicks trolls all of a sudden. Here we go.
You know, I'm watching the New Yorkers.
Yes. Yes. So let's talk a little bit about the Pregnant Workers Fairness Act, just a little bit of background to set the table here, okay? So the act aims to protect pregnant workers from discrimination and ensure that they receive reasonable accommodations during, and here's the key, pregnancy, childbirth, or for related medical conditions so that pregnant employees can stay employed. And that's not just for current pregnancies, it could be past pregnancies, it could be for people who are trying to get pregnant. So this is a very broad law. It addresses gaps in existing laws and emphasizes the importance of workplace fairness for pregnant employees. And it also allows pregnant employees to keep working while they are pregnant in order to protect their economic security as well as their health and the health of their pregnancy. The EEOC issued a final rule to implement the PWFA, which was published in the Federal Register on Monday. And the regulation becomes effective, 60 days from today. It covers employers, unions, employment agencies, employees, applicants, and former employees currently protected by Title VII, the Civil Rights Act of 1964, and a couple of other laws as well. You'll see today, and I apologize in advance, the focus is going to be on private sector employers, just because we may not specifically mention employees and employers in the public sector, whether state or federal. It doesn't mean that, it doesn't apply to you as well, but we're going to focus mostly on private sector employers, because that's really what Amy and I mostly do in our private practice. Amy, there are a lot of definitions in the Pregnant Workers Fairness Act that are well-defined, not so well-defined, and not really defined at all. And that's where the EEOC has come in with its final regulations to try and create some form of clarity for employers and employees. Want to talk about some of those key definitions and concepts?
I very much do. So as an umbrella concept, in a lot of ways, the Pregnant Worker Fairness Act mirrors the ADA, the Americans with Disabilities Act, both in what it provides and in the definitions. But in a lot of ways, it doesn't. So let's dig into this a little bit. Eric had mentioned that the Pregnant Worker Fairness Act protects pregnant workers from discrimination and ensure they receive reasonable accommodations during pregnancy, childbirth, or related medical conditions, and that's for a known limitation. Those words, known limitation, both have separate meanings and both have meanings together. Known just means that an employee has to tell the employer. And when I say employee, that could be an employee representative. If an employee's in the hospital dealing with a situation related to pregnancy, childbirth, or a related medical condition, that employee's mother, father, spouse, child, sibling can contact the employer. And when I say employer, in terms of the employee must communicate the condition to the employer, that means a supervisor as well as human resources. So we'll dig into a little bit of those best practices later in terms of who needs to be aware of, this law and the guidance interpreting it.
Yeah, everyone gets to do a shot every time we say train your supervisors.
I know.
Don't do that. Don't do that.
Oh, for all y'all having liquid lunches.
Yeah.
That's not us. So known limitation. A limitation, kind of like under the ADA, is a physical or mental condition, but it's got to be related to, affected by, or arising out of pregnancy, childbirth, or related medical condition. Now, a little bit of variance from the ADA. Such a limitation can be modest or minor or just episodic. That makes me think of somebody with morning sickness, right? Occasional morning sickness, who occasionally has a limitation because of the morning sickness. Modest, just, they may require just additional bathroom breaks, that type of thing, because of the baby putting pressure on a bladder, right? So it could be modest or minor, but it must relate to the employee's health, physical or mental health, or the health of the pregnancy, or it's got to do with seeking related health care. Okay, and seeking related health care is not just OB appointments, it could be therapist appointments to deal with postpartum depression, right? Depression relating to a pregnancy or childbirth. It could deal with seeing a therapist for anxiety, the anxiety, from dealing with something related to pregnancy, childbirth, or related medical condition. And for anyone who's on the phone who's been pregnant, you probably know a million other situations. I could give you more, but we don't have that kind of time. It's broad. The bottom line is a known limitation. That limitation is very broad, but still the employee has to tell the employer. Now, the big definition, Eric and I were talking about this previously, is the Pregnant Worker Fairness Act only protects qualified employees, right? Just like under the ADA. You remember an employee with a disability under the ADA An employee who's a qualified employee entitled to an accommodation has to be able to perform the essential functions of the job with or without accommodations. So like the ADA, an employee or applicant who with or without reasonable accommodation can perform the essential functions of the job is qualified, right? Now, the Pregnant Worker Fairness Act allows an employer applicant to be qualified even if they can't do one or more essential functions of the job if the inability to perform the essential function is temporary, or the employee could perform the essential function in the near future, right? And the inability to perform the essential function can be reasonably accommodated. Those are all buzzwords, right? Temporary, in the near future, and they all relate to the definition of qualified.
And this is where Congress saw fit to include these words and phrases without defining them. So this is a big part of where the EEOC steps in to fill in or purport to fill in those gaps.
That's the interpretive guidance aspect of it. And this was done, obviously, of course, after public comment, and the EEOC, I think, does a great job in discussing what the public comments are, for or against the specific definition or wording or whatever, what have you, and then addressing why it's taking a particular stance. Now, in terms of temporary and in the near future, for some positions, this may mean that one or more essential functions are temporarily suspended, right? With or without assigning that essential function to someone else, and the employee continues to perform their remaining functions. For other positions, some of the essential functions may be temporarily suspended with or without assigning the essential functions, right? And the employee may be given other tasks, another job to do to replace them. So you can see that the fact patterns in these types of situations really are significant. It's really an individualized assessment, just like under the ADA. Now, temporary is not defined in the Pregnant Worker Fairness Act. The regulations just say it's lasting for a limited time, not permanent, and may extend beyond the near future. And reading this, you're like, what the heck does that mean? Lasting for a limited time. Is that a week? Is that 2 weeks? Is that a year? Right? In the near future, the regulations define that as 40 weeks from the start of the temporary suspension of essential functions. But, and as Eric and I say all the time, both on these Zooms and in blogs, it depends, right? It depends, because it could be less than 40 weeks, but because there's that 40-week line, the EEOC is taking the position that temporary can mean just right up to 40 weeks. And they add this to the definition of qualified because it would often be difficult, if not impossible, for a pregnant employee to predict what any limitations they have will be when they return to work. While pregnant, they may not know whether, and if so, for how long they'll have a limitation or need an accommodation. And they also may not know whether an accommodation after returning to work will require the temporary suspension of an essential function, and if so, for how long. Things vary from trimester to trimester often, and sometimes from week to week, whether we're talking about pregnancy, childbirth, or a related medical condition. So the final rule, this is important to note, the final rule differs from the proposed rule in that 40-week period applies when the condition for which an accommodation is sought relates to a current pregnancy. So that is what a qualified person is under the Pregnant Worker Fairness Act. We could talk about the essential functions and the undue hardship definitions. Those are the same as under the ADA, right, Eric?
Yeah. There's enough to for employers to grapple with in terms of, and we'll get into it in a little bit, the interactive process and the types of reasonable accommodations and what accommodations employers should be providing pretty much automatically without with limited, if any, pushback, but at least we have some commonality between the Americans with Disabilities Act and the Pregnant Workers Fairness Act, which is essentially, I don't want to say bolted onto the ADA, but modeled in large part after the ADA, with many of similar concepts, namely essential functions and undue hardship.
Yes, yes. And I think that's so important. The undue hardship question, especially, what's an undue hardship? I hear this. I know you do too, Eric. I hear this all the time from clients that it's an undue hardship to provide an accommodation in some cases. First of all, remember, y'all who are small businesses, it doesn't apply to you. If you have less than 15 employees, then this law just doesn't apply. And it's a different story. You may have state law issues, but the rules identified a limited number of simple modifications that will, in almost all cases, be found reasonable. But undue hardship is one that's really specific to the organization. It creates a significant expense or operational problem for the company. And it's a case-by-case situation aspect. There's no bright line rule here. I wish there was. But then we wouldn't have jobs, would we, Eric?
That's true. That's true. We've already used up a couple of it depends, which I know probably throw people off because they're used to their own lawyers using that. But here we are.
That's very funny. So, and as Eric noted, thank goodness some of these concepts are the same. The interactive process is the same. It's just a conversation, right? It's just a talk. You want to engage in that interactive process as an employer, because the failure to engage in it once you know an employee has requested an accommodation could result in liability, right? If you fail to just engage in the interactive process alone, that's not a violation. So it depends on the facts. It depends what if the employees let you know or not. Another frequent question, you want to talk about reasonable documentation, Eric? Such a frequent question.
I must admit, I was monitoring. Can you start on that? I have to find that.
Of course. I just thought people might get bored of me, but of course. Okay. So reasonable documentation. Can I ask for documentation about the employee's pregnancy, childbirth, or related medical condition? Yes, you can, maybe, right? It depends. So you can ask for the minimum documentation that is sufficient to confirm the physical or mental condition, confirm the physical or mental condition that it's related to, affected by, or arising out of pregnancy, childbirth, or related medical condition, and describe the change or adjustment at work needed due to the limitation. If it's obvious, you can't look at a pregnant person who is very obviously pregnant and say, please may I have documentation of your pregnancy. It can't be obvious. If it's obvious, there's no need for documentation. And this was also a difference in the final rule from the original one. It's minimum documentation that is sufficient to confirm that the condition is related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. The physical or mental condition doesn't need to be a disability. You don't have to do that analysis, wondering whether it rises to the level of a disability. Does it impact a major life activity? No, doesn't have to be a disability at all, but it can be in certain circumstances, of course. Of course, there are places where the Pregnant Worker Fairness Act and the ADA overlap.
Right. You could have someone with high blood pressure, or someone with, that's usually the one that comes to mind, but an underlying disability that the pregnancy causes to, there's an episodic event of the underlying disability. So at that point, the ADA would be in play. But again, as Amy said, there doesn't need to be an underlying disability because the Pregnant Workers Fairness Act isn't a disability accommodation statute. It's a pregnancy accommodation statute.
Right. And there are circumstances where you cannot seek reasonable documentation. You really can't seek documentation, as I said, when it's obvious, or when you already have information sufficient to support a known limitation, or when the request is for one of 4 specific types of reasonable accommodation that the EEOC has deemed presumptively reasonable and that you should just provide as a matter of course.
Right. All right. Why don't I talk a little bit about reasonable accommodations? And first thing, when you're accommodating an employee, first of all, the definition is the same as the Americans with Disabilities Act. Start there. Second of all, like with the Americans with Disabilities Act, employers should not be considering mitigating measures when determining whether someone has a limitation related to pregnancy, childbirth, or related medical conditions. So under the ADA, right, you don't look at someone who has issues seeing and you ask them, okay, put on your glasses, and now let's see if your sight issue has gone away. Same principle applies to the Pregnant Workers Fairness Act. Employers have to provide reasonable accommodations to qualified employees or applicants. Let's not forget that. We're focusing so much today on employees. But if you're a nerd like Amy and I, you write about this stuff, you practice this stuff, you need fodder, especially when you're doing a blog post. You go over to the EEOC's website and you look in their newsroom, right? And you look and see what the EEOC, what kind of cases they're settling, what kind of lawsuits they're bringing. And there are so many cases they bring, especially under the ADA, with respect to applicants who either aren't accommodated in the process, in the application process, or allegedly have job offers rescinded because they reveal voluntarily that they have some sort of disability. And the same type issues can apply under the Pregnant Workers Fairness Act. So without giving it short shrift, but without emphasizing it too much, because we're focusing a little bit more on your current workforce, just remember, train your folks that the duty to accommodate under the PWFA applies equally to applicants with known limitations related to pregnancy, childbirth, or related medical conditions. Just like in an interview, you wouldn't be asking someone, so you pregnant? Like that shouldn't come up, generally speaking. And more likely than not, unless the person is showing and it's obvious, they're probably not going to divulge it to you because they may be concerned that they would you might use that in your hiring decision. So
you don't want to assume. You don't want the Pregnant Worker Fairness Act does raise that issue that you don't want to assume that somebody is going to get pregnant.
Right.
I think that would be obvious too.
Right. I see someone in the chat. It says, this wasn't a question. This was more of a statement. Discuss the crossover with FMLA. I promise you we will do that. Accommodations should not impose undue hardship on the business. An employer may request reasonable documentation. We talked about that already. And an employer must choose an accommodation through an interactive process. This is important, okay? An employer learns that someone is pregnant or requires an accommodation. This falls under the PWFA. The employer has to go through an interactive process with the individual. Now, it could be simple, right? And we'll talk about this in a little bit. There are certain accommodations that are just patently obvious. Someone who's pregnant wants to carry around a bottle of water. Do we need to have an interactive process over that? Okay, sure. Go ahead, carry on a bottle of water. Someone who's pregnant might need to sit a little longer or stand or take breaks. Do we need to have an interactive process about that? No, it's common decency. Just let someone sit and stand.
Yeah, but we're going to have those cases at certain stores and certain places where the cashier is not allowed to sit or something like that.
See where you're going with this. We can't call out particular employers that may or may not be frequent flyers in the EEOC's newsroom.
Yep.
So we're not going to name them by names. We're not even going to say what they sound like.
That's right.
Address it, go in the newsroom.
Stores.
Right. But the employer must choose an accommodation through an interactive process that provides the qualified employee or applicant equal employment opportunity to attain the same level of performance or to enjoy the same level of benefits and privileges. This is important, as are available to the average employee with a known limitation who is similarly situated. All right, so obvious one here, and this pre-existed the Pregnant Workers Fairness Act. You do not insist that a pregnant worker take leave. Okay, that's a problem. Don't insist on that. If a pregnant worker asks for leave, all right, you have an interactive dialogue about that. Okay, but demanding that a pregnant worker take leave, even if it's for the health of the woman and her unborn child, don't do it. Don't do it. You're going to end up in the newsroom. Okay. All right. Also, with respect to the process of accommodating an employee who needs that accommodation, an employer cannot justify failing to make a reasonable accommodation or unnecessarily delay. You can't delay, but you can't certainly unnecessarily delay in providing a reasonable accommodation based on the employee or applicant failing to provide supporting documentation, unless, okay, the employer seeks the supporting documentation, right? Seeking supporting documentation is reasonable under the circumstances as the EEOC has laid it out in the final rule, all 400 some odd pages. The supporting documentation is reasonable documentation as defined in the rule. And the employer provides the employee with sufficient time to obtain and provide the documentation. All right. So it's a 4-step process. And I said, and there's no or in there. So you gotta tick all of those boxes. All right. An employee is not required to accept an accommodation, but if they reject one, they risk not being quote unquote qualified. All right. And whether the employer can reasonably accommodate the person's inability to perform the essential function, that gets reassessed when the employee returns to work from pregnancy or childbirth, regardless of whether the employer provided the same accommodation or a different one beforehand. Okay, so accommodations can change based on time and situation, post childbirth. That makes sense. It's logical.
Right.
And go ahead, Amy. I'm sorry.
Back on what you said, just to piggyback on what you said about reasonable documentation, which I feel like, especially with our big companies, is it really, you're trying to keep track, and we rely a lot on forms, right? We rely often on paperwork. So you can, the EEOC clarified that reasonable documentation just means the minimum that is sufficient, rather than just saying reasonable documentation means documentation that is sufficient. So what are they saying? What they're really saying is don't overly rely on the need for documentation to provide accommodations. It's the minimum that is sufficient. And once they made that decision, they changed the language in the regulation to specify that the supporting documentation just needs to confirm the physical or mental condition. It's not like under the ADA, if somebody has a mental condition like ADHD, just take that, right? And they're seeking a reasonable accommodation. You want to understand how the limitation, arises in the workplace, you want to connect the disability and the limitation to arrive at the accommodation. We know that. Here, I would say, interpreting this, it's a little bit lower. The standard's a little bit lower. The supporting documentation just needs to confirm, not describe or confirm, but confirm the physical or mental condition. So, remember that physical or mental condition may be modest or minor or episodic. you are basically you're going to want to, accommodate and not overly rely on documentation.
I see a question right now. It's just perfect timing. It's an easy one to answer. Nadia asks, can the employer initiate the interactive accommodation process if the employer notices that the pregnant employee has a hard time accomplishing her regular tasks? Yeah, absolutely. Right.
Yeah.
And this isn't specific to the PWFA. This is under the ADA as well, right? You wouldn't ask someone if they're pregnant. You wouldn't ask someone if they have a disability, but it's as simple as, hey, I see you're having a little trouble here. How can we help you? What can we do to help? Is there anything we can do to help? You don't even have to couch it in terms of, hey, I see you're pregnant. What can we do to help? You can just literally say, well, how can we help you? And the response may be, I'm good. Or the response may be, yeah, maybe you could do this, this, and this for me. I didn't realize that I could get help because of my pregnancy if I needed it. Now, hopefully your employees understand that they can get that, and you're educating them on that, you're training them on that. But yeah, you can certainly initiate the conversation with an employee. Okay. Let me give you some examples of reasonable accommodations that are in the regulation. This is not an exhaustive list. It's not an exclusive list. It's just a list of specific accommodations that not are per se reasonable, but are presumed to generally be reasonable. So frequent breaks, that's one of those that's more along the lines of, yeah, that's going to be reasonable pretty much like 99 times out of 100. Sitting and standing, schedule changes, part-time work, paid and unpaid leave, including time off for doctor or healthcare appointments, including in vitro fertilization. I had IVF in my notes. I'm pretty impressed. I knew what that stood for. Telework. I'm sure no one has any questions about that. Remote work. Anyone? I don't deal with that 24/7, 365. Parking, light duty, making existing facilities accessible or modifying the work environment. This should sound very familiar because these are accommodations that work under the ADA too, generally. Job restructuring. Now, here's where things get a little bit different. Under the ADA, you never have to suspend or remove an essential job function. Under the PWFA, you do need to temporarily suspend one or more essential functions if it's reasonable. If it's reasonable, right? It doesn't create an undue hardship. Acquiring or modifying equipment, uniforms, or devices. If you have someone who, again, I'm trying to be delicate with this, no longer fits into their uniform because they are pregnant, get them a new uniform. That's an easy accommodation, really easy, okay? And adjusting or modifying examinations or policies. Okay, those are the examples.
That's such a big one, Eric. I'm going to interrupt you for a second.
Yeah.
Because I think that employers often push back on the idea of modifying their policies. But that attendance policy may need to be modified. That, maybe cell phone policy may need to be modified. That leave policy may need to be modified to accommodate a pregnancy, childbirth, or related medical condition. And in this final rule, the EEOC talked about employers ensuring that technology is appropriately adjusted to integrate the accommodation, right? Because employers are increasingly using technology to monitor attendance or track productivity and performance. So it's important to consider how a reasonable accommodation might impact the accuracy of these tools.
So let's talk a little bit. I'm going to jump off of the reasonable accommodations for a bit. First, I'm going to reset about halfway through, a little over halfway through. You are watching the Employer Handbook Zoom Office Happy Hour. I'm Eric. That's Amy. We're talking about the Pregnant Workers Fairness Act. If you've hung in here this long on YouTube, thank you. Don't forget to click like and subscribe and comment below and all that good stuff. We have a couple more things to cover, and then I want to save plenty of time for Q&A. And the other things, I'll tick them off really quickly. We're going to go a bit out of order and do some of the best practices before the Q&A, I think. Talk about the enforcement mechanisms for the Pregnant Workers Fairness Act, procedures for filing charges or claims with the EEOC under the PWFA mirror those under existing statutes like Title VII, for example, and the available remedies, including the damages, align with existing laws. A best practice, again, as we go out of order here. And
I mean, you
already talked about it. We're going to say it again. Employers, I know this is new to you, and you may want to train it, train your HR department first, but at some point, you got to train your managers on this. This is important. If you haven't already done so, there may be state laws that have raised the bar where even above the PWFA, and you've already done the training, great, you're ahead of the game. But in many states that don't have a pregnancy accommodation statute, this is the time to do some training, update your handbooks and the like. And employees as well. And that's comes through the handbook updates primarily, but also some training would be good too. Need to be aware of their rights and how to request accommodations. That's
right.
really.
EEOC has a poster, which I just put in the chat.
Oh, thank you, Amy. Appreciate that.
Always there to serve.
And the PWFA contributes to a more equitable workplace by ensuring pregnant workers are treated fairly and provided the necessary support. So beyond just the training and the handbook updates, be an advocate, raise awareness, and foster a supportive environment for all employees. I know every once in a while on these things, we get some snarkiness in the chat, but I think we can all agree that we're looking out for all of our workers, and pregnant workers now and in the future and beforehand. And now I'm rambling. We need to be supportive. need to support them during and after, of course, their pregnancy. Okay, we have many questions that were submitted in advance. We're going to give priority to those. If we get through those and we see that there are plenty of questions in the chat, some of them overlap with questions that have already been asked. So that's why I haven't jumped out of order too much, but let's get through these questions that were submitted in advance. I'm not going to identify the people who submitted them, and they might not be, if you submitted questions, I'm pretty sure we'll get to it, but they might not be word for word the question you submitted. Some of them were pretty darn specific, and I feel like I'd be giving legal advice if I responded to them. So I tried to generalize the questions as much as possible. All right, Amy, first question to you. Ready?
Yes, I'm ready.
Okay. What are an employee's duties to accommodate an employee who wants to breastfeed without any associated medical condition?
So that's a good question. And that implicates not just the Pregnant Worker Fairness Act, but the PUMP Act as well, which requires employers to provide break time for employees to nurse. Now, breastfeeding is a condition that arises from pregnancy and childbirth, right? If the employee has conveyed a known limitation, right, has told the employer or HR or the manager or whomever, and requests an accommodation, i.e. the need to express breast milk and pump at work, she is asking for a reasonable accommodation, which is just as we talked about, a change or an adjustment at work due to the limitation. If she's able to perform the essential functions of the job with the reasonable accommodation of time and space to pump, the employer has to grant the accommodation absent undue hardship or another reasonable accommodation that they request. Now, Eric, let me ask you a question.
Right.
Should employers adopt separate PWFA and state-specific pregnancy accommodation handbook policies?
Yes.
Can you elaborate?
Well, I'll use Pennsylvania, for example. So I'm licensed to practice law in Pennsylvania. In Pennsylvania, we have the Pennsylvania Human Relations Act, which is a semi-robust anti-discrimination statute that covers pregnancy, but it doesn't have a specific accommodation. There aren't specific, it's not as specific as the PWFA. So there I wouldn't be as concerned as having a separate Pennsylvania specific accommodation policy. Now, if I'm in Philadelphia, right, they do have specific pregnant worker accommodations that are contemplated under local law. If I'm in other states, New Jersey, I'm not licensed to practice in California, but I would imagine California. So there are certain states that already have heightened accommodation obligations. And in those states, I would want to have a specific state-specific accommodation policy to the extent it diverges from the Pregnant Workers Fairness Act. And just as a general, you'll probably know this already, for multi-state employers, right? You're going to have generally your general handbook and then your state-specific supplements or state-specific provisions interspersed into the handbook, however you choose to set it up. Okay. Amy, it's not like we scripted this at all. Is there a direct threat analysis that applies to the Pregnant Workers Fairness Act as it does under the ADA?
Yes. I love that question. It was something I really hadn't thought about when going through the EEOC guidance on this issue. The direct threat idea is under the ADA providing a reasonable accommodation, but there's an exception if there's a direct threat to safety or health of other people or the employee themselves. So there's no direct threat defense that is applicable to the PWFA. Generally, an employer wants to provide accommodations unless there's an undue hardship. And that's what you want to focus on, is that undue hardship. If there's a safety risk just by being pregnant, an employer is going to have to meet the BFOQ standard, which is a legal term. I can't remember the BF, but otherwise qualified.
Bona fide.
Bona fide occupational qualification. If somebody who's pregnant, I don't even know what a bona fide occupational qualification would be. I mean, I'm thinking first of a construction worker, but they could probably do the work. You can't assume something is going to be a risk to a pregnant employee, right? It's got to be a conversation, an interactive process that is, of course, documented. So your defense will be meeting that BFOQ standard. If the undue hardship is due to safety, the PWFA requires employers to really engage in that interactive process and see if there's another one. I'm sure there will be another one.
And employers, when it relates to safety, obviously safety is paramount, not just for the pregnant worker or someone who's just had the child, the woman, but also to coworkers. Okay. So that's important. But employers should not be stereotyping. And this is a trap, not just under the Pregnant Workers Fairness Act, but under the ADA, that something is a safety hazard, right? Or a direct threat, even though that doesn't apply here. If you have questions about whether something is a safety threat or someone's condition creates a safety threat, a safety issue, talk to an expert, right? You can consult with a lawyer, but we're not doctors. We're not safety experts. Talk to people and get that information so that when so that will enable you to have an interactive dialogue, and if necessary, push back on people who are insisting on continuing to perform a certain job function or the like.
Absolutely.
I don't know if I want to answer this next question.
I'll take it.
Okay, I'll ask it to you. Amy, how does the Pregnant Workers Fairness Act address menstruation and menopause?
Okay, so it's likely included. It's going to be an it depends situation, which is much more aligned with the ADA. So it's likely included in the definition of pregnancy, childbirth, and related medical conditions. So like with Title VII, right, menstruation can be protected when it has a nexus to a current or prior pregnancy or childbirth. The courts are really making these decisions on a case-by-case basis, but it's likely that when it rises to the level of a disability, the best case for that I can think of is endometriosis, which is so common in female employees or people who identify as women in their 20s, or when they're perimenopausal. So, and not to sound like a doctor either, but maybe some women have personal experience. So endometriosis is just crippling pain, and it might rise to that level of a disability where accommodations are needed. So it will depend. And the same is with menopause. Some people have such extreme, menopause is not considered a disability under the ADA. There's legislation in the UK about menopause, but not really, it's less of a conversation here in the US. But if it rises to the level of a disability, menopause can also be part of that equation. But it really, really depends on how it relates to a related medical condition. Now, I'm going to give you this one because I know you love this. This is
Go ahead.
Eric's favorite. It's your favorite, I feel like. How should employers calculate 40 weeks when excusing essential functions? And can that 40-week period restart?
Well, generally, it starts when you give the accommodation for the pregnancy,
Yeah.
and it's generally 40 weeks. It doesn't have to be 40 weeks. It could be less. I guess conceivably it could be more. And I think this is one of those areas. I'm going to go on a tangent here. I'm going to try and not make this a rant, but this is one of those areas where I think the EEOC's final rule could be subject to court scrutiny, especially if the Supreme Court rules on a case this year that affects how much deference courts are required to give to agency determinations, agency rules on federal statutes. Because the 40 weeks, it's not, they didn't like throw a dart and hit on 40 weeks. I mean, there's some nexus, of course, between 40 weeks and the term of pregnancy, but it's still not in the statute, and it's something that the EEOC came up with. So the quick answer to Amy's question, I'm reeling it back in, I'm trying not to get too far out there, is it's generally 40 weeks, starts when the accommodation begins, and it could restart with a new pregnancy. All right.
Absolutely.
Another question, under what circumstances will a burden on coworkers or the expense of hiring temporary replacements create an undue hardship? So we see this come up a lot. Productivity, morale. Amy, what do you think?
Yeah, I mean, it's the same answer, right? It depends. It's an individual assessment. It depends on your workplace. It depends on what kind of expense you're going to incur or what kind of operational difficulty it entails. It's the same definition. That undue hardship is the same definition as under the ADA. So if providing a reasonable accommodation is going to be unduly costly, extensive, substantial, or disruptive, or would fundamentally alter the nature or operation of the business, then it could be an undue hardship. And if it is, without giving any legal advice, as we say in the blog, you know, the Pierson Ferdinand blog and Eric's blog, the employer handbook, you want to document that situation, you know, if there's any kind of undue hardship. The final rule implementing the Pregnant Worker Fairness Act has a ton of examples on this. And because I am such a nerd and because I did look at this all through my plane ride back, I'm going to go through some of them with you. Well, I'm not going to go through some of them with you, but if you go to the final rule, it's on page 351. There's paragraphs with scenarios, and that will give you just some good examples of what it looks like when there's an undue hardship.
All right.
Now, Eric, let me ask you a question.
Yes, please.
Can employers reduce pay when compromising performance standards as an accommodation for a pregnancy?
So when I first saw this question come in, I thought about it and I thought, well, how would you do that in real time? Because you're paying someone by the hour, you're paying them salaried, right? You're not going to like go back and say, well, they're pregnant, and because they were pregnant, they only put together 80 widgets instead of 100 widgets, so we're going to dock their pay by 20%. That would create a Fair Labor Standards Act issue, and it may create some state law issues as well. But I think what we're getting at here is going forward, like you're about to accommodate someone, you realize that it's going to result in productivity issues. Would you reduce their pay?
Prospectively?
Yeah, I wouldn't do that. Now, if someone needs a flexible work schedule, right, they're going to come in, they're going to work 6-hour days instead of 8-hour days. Yeah, you can adjust their pay accordingly, of course. If they're going to take days off, unpaid time off, yes, you would adjust their compensation accordingly. But would I prospectively lower someone's pay because they're pregnant and they might not have the same productivity? Yeah, that feels like a penalty to me. That feels like you're going to get yourself into trouble.
In some states, I mean, you're not going to reduce pay. You're going to get in trouble with some states. I mean, New York deems it a criminal penalty. You know, if you're withholding pay from an employee in certain circumstances. So you want to be aware not just of the PWFA's, you know, application here, but your state laws as well, especially when it comes to reduction in pay.
If I ask you this next question, that means you're going to ask me the question after that.
We could do it together. Let's do
okay, fine.
Okay, so everybody's happy question, right?
Well, let's do this one. Let's do the FMLA overlap question that we foreshadowed, and then the next one will be the trigger question.
Okay.
Everyone's got to be shocked we haven't mentioned yet. Amy, does the Pregnant Workers Fairness Act conflict with the FMLA? And here's what we're getting at. The PWFA makes it an unlawful employment practice for an employer to require a qualified employee to take leave, whether paid or unpaid, if another reasonable accommodation can be provided. Okay. Now, the FMLA covers prenatal care, and an employer should, as we know, designate FMLA qualifying leave as such.
Right.
But what if an employer rejects an employer's attempt to designate prenatal care as FMLA leave? Is that a problem? You know, can employers request documentation for prenatal appointments? So here we have this overlap between the PWFA and the FMLA.
Yeah, I think that's tricky, don't you?
I don't know. Here's the thing. If someone needs a prenatal appointment, we're not requiring them to take leave. Like, you can take leave, right? I have to go to my doctor's appointment. Fine. That is FMLA designated, right? Because it relates to the pregnancy, and it's unpaid leave under the PWFA, unless under both statutes that the employee has PTO in the bank and wants to use a PTO day, or maybe the employer has a policy that, you know, it runs concurrently. I don't see any issue with that. And can you ask for documentation to establish that someone has gone to a doctor's appointment? Of course. Yeah, you don't have to take their word for it. So yeah, I don't see the conflict, and maybe.
But on the other hand, why would you request documentation for like a pregnant person going to a doctor, especially in the second or third trimesters of pregnancy when they're very obviously pregnant?
Fair enough. And that goes to how you treat pregnant workers compared to the rest of your workforce, right? Correct. If someone says, hey, I'm taking the day off today to go to a doctor's appointment, and you don't ask for a doctor's note, and you may not be able to ask for a doctor's note under certain state laws. Sometimes people have to be out for like 3 days before you can ask for a doctor's note in particular states. If you're not going to ask for a doctor's note from the guy who's going to get, you know, going for his physical exam, you better not be asking for a doctor's note from the woman who's going to a prenatal appointment. You gotta be consistent across the board. That's important. Oh, darn, we're out of time. No, fine. We
While
got,
providing an individualized assessment, of course. It's not confusing at all.
I don't know. Aim, we're like so close to being out of time. Should we answer this next one?
Oh, come on.
All right, fine.
I'll help you with it.
Fine, fine.
I love this question.
Here we go. All right, folks. What Pregnant Workers Fairness Act exemptions exist for religious employers whose beliefs are against abortion? Because abortion is covered under the Pregnant Workers Fairness Act. You have to provide an accommodation.
Hard stop on that. I mean, that's what the EEOC says. The EEOC says you have to cover it in the same way when people are seeking an abortion, they're pregnant, right? So it relates to pregnancy. The EEOC is not advocating for or against abortion or telling employers what to cover for their benefits or travel benefits or anything like that. It just arises out of pregnancy. Now, in terms of an exemption for religious employers, it's a defense, right? Like undue hardship called the ministerial exemption. Under the exception, a religious organizational employer, right, may employ people who personify its beliefs. That's the verbiage in the ministerial exemption, that shape its own faith and mission or minister to the faithful. That's the language. The exception applies to discrimination claims involving the selection, supervision, and removal by a religious organization of employees who perform vital religious duties at the core of the mission of the religious institution only. There's been really fun case law out there about, the termination of an employee because of their sexual orientation by a religious organization when that employee just directs the choir, right? And there's a lawsuit about that because according to the employee, they were not performing vital religious duties at the core of the mission of the religious institution. They were performing secular duties, right? This goes back to the final rule. It's rare, so rare that an employee, of what, 300 of you on this call, that an employee is going to tell their employer, I need leave for an abortion. I've never had it come up in practice, and nearly, I'm not going to say how many years in practice, but a lot of years in practice. I don't think it's going to come up a lot. And if it does, it does. But that ministerial exemption really does exist for that very specific organization that is faith-based and needs employees whose work, whose position, whose function is steeped in that mission and faith.
Yeah, and the EEOC, I remember seeing that they're going to come out with they will come out with some guidance on this, and there could be some constitutional arguments, there could be some religious freedom Restoration Act arguments. This is candidly not my area of expertise. However, we will get more guidance on this in the future. I can tell you this: if there are individuals within the organization who are stonewalling, like the person in HR whose personal beliefs conflict with giving someone leave for an abortion, like that's not an excuse to deny the leave, right? Okay. We're at the top of the hour. I can answer these last two questions really quickly. Well, how should employers accommodate pregnant workers who must travel for their jobs but can't? Just don't make them travel temporarily, since they will be able to do so again in the near future, unless it could create an undue hardship, presumably. But that's kind of the general baseline answer. And someone asked, do these final regulations affect the injunction in Texas? No, they do not. So in case you didn't know, a federal judge in Texas entered an injunction against the Pregnant Workers Fairness Act. So Texas employers, that's it, do not have to comply with this. We're at the top of the hour. Amy, audience, thank you so much. Anything you want to promote? Anything you want to plug? Anything fun going on this weekend? What do you want to tell the audience before we wrap up?
So I so appreciate the opportunity to talk about this with you. Just so you know, Eric and I have worked together for years. And when these regs dropped, I immediately texted him in all caps and knew that at the time I was reading all of these 400 regulations that he would be too. Employers all over, and employment lawyers, especially the nerdy ones like us, have been waiting for this final rule. So we're thrilled to be able to bring this to you and talk about this. If you have any questions at all, please don't hesitate to reach out to us, connect with us on LinkedIn. We love hearing from you. We love talking to you. And if you have, that's really it. I'm not promoting anything. I'm just happy to be here and happy to answer questions about this.
Awesome. Well, folks, again, thank you so much. We will add a link to this recording, the blog. I'll post it on LinkedIn as well. I put something in the chat about connecting with us on LinkedIn. Please do that. And everyone, have a great weekend and go Sixers.
Go Sixers.